Hi guys, so if we're going to jump on here today, it's actually a very interesting actual topic where we're looking at five very notable cases and examples out from the Cook Islands itself, kind of displaying its level of asset protection, right? It is known as the gold standard. And again, if you haven't met me before, it's Will from 4-Point Solutions. We speak about offshore trusts, offshore companies, tax residency. We speak about a bunch of stuff in finance, right, from fintech to actual personal structures as well. And in this video, we're going to be showcasing the strength and in some cases the limits of the Cook Islands trusts, so you can really understand the level of asset protection that it does actually offer, right? So firstly, we actually have the Anderson case, which is, it was called Affordable Media, and it was against the FTC. So there's a landmark case where basically the US Federal Trade Commission suit sought to access transferred assets which was transferred into a Cook Islands trust, right? Despite the trust being very poorly drafted, with the settlers named as the co-trustees. The Cook Islands courts upheld the trustees' position and invalidated the FTC's attempt to seize the actual assets. And ultimately, the FTC settled rather than to continue the actual litigation. The second case that we actually want to be looking at is the Branch Banking and Trust Co. versus the Hamilton Greens, right? So this is where the Ballinger defaulted on a $3.3 million loan and transferred $1.7 million into the Cook Islands Trust soon after US courts labelled it a fraudulent transfer. But the Cook Islands trustee again refused to return the assets, underscoring the jurisdictional protection that the Cook Islands does offer. I know it's very well known, but no one actually really goes into the cases, right? I was speaking about it with a client literally on a Loom call earlier, and I thought it'd be a great topic to make a YouTube video on, to really make people aware about this level of asset protection. It's extremely special. The next one is the Reese Smith, which is a US bankruptcy actual case, where Smith was basically formed a Cook Islands trust and transferred about $6 million in assets just before a judgment was actually issued against him, okay? While the US courts considered it fraudulent conveyance, it didn't compel the Cook Islands again, where the Cook Islands trustee did not comply at all, and enforcement would have required little actual litigation in the Cook Islands itself. Another one was a very high-profile divorce case. I think it was over, she was entitled to $45 million apparently, or something like this. And she challenged assets on her ex-husband, who transferred assets into the Cook Islands Trust. The same day she was divorced, $45 million was actually transferred. And the court found the timing, it was a fraudulent transfer, according to the US courts. And then his ex-wife actually succeeded in this. Now, this is because of the timing. It's the same day at the end of the day, But then we can go into another case number 5, where a Russian oligarch claimed, a Russian court claimed funds transferred to the Cook Islands that were illicit, apparently. And the Cook Islands High Court rejected the claim, finding no evidence that the trustee was aware of any wrongdoing, thus blocking the actual Russian actual high courts. So there's some other ones. Kevin Trudeau, I used to listen to his books called Your Wish, Your Command. After being ordered by the US court to pay $37.5 million, his assets were held in the Cook Islands Trust, remained untouchable. He served jail time for the contempt rather than disclosing the trust details, and no assets were ever recovered. There's a few other ones where we're facing a $7 million judgment. They transferred approximately $25 million into a Cook Islands Trust. US courts expressed jurisdictional concerns, and ultimately the party settled without touching the trust assets. And another one, in 2002, the US court held transferring assets into a foreign self-centered trust cannot shield a debtor from bankruptcy, even in the Cook Islands, if the structure is aimed at frustrating creditor claims, okay? So the summary here is even poorly structured trusts were upheld by Cook Islands courts over US courts, right? Stress test of fraudulent and transfer defense. So there has to be, significant time before obviously these court cases come. US bankruptcy avoidance doesn't override the Cook Islands trustee obligations. Fraudulent transfer timing can pierce a very well actual structured trust. Foreign government claims are defensible if trustee lack knowledge of the actual wrongdoing. And strong deterrent effect, meaning the actual creditor is barred from recovery despite significance of US judgment. Settlement instead of enforcement illustrates how, asset protected it actually is. But at the end of the day, the Cook Islands Trust generally remain resilient against foreign judgments unless challenged directly in the actual Cook Islands courts, and a trust actually structured too close to a legal threat would obviously kind of cause a problem. Now, when we speak about setting up an offshore trust, it's quite complicated, right? And if you did obviously want to perhaps drop me an email, you can book in a Zoom call. The links are down below, right? But when we actually go into this, there's also there's many effects, right? And at the end of the day, the Cook Islands is one of the strongest, if not the strongest, asset protection levels in the entire world. And that's something not to just let go away, You could look at a DIFC foundation over in Dubai, a Liechtenstein foundation, a trust or, a self-managed pension trust over in Guernsey. But they do not offer the level of protection that Cook Islands does. Nevis comes very close to it. Nevis is also a very famous haven, essentially, for asset protection. And again, what's very important is they require proper drafting, trustee independence, which is very key, okay? And this is on the Anderson case, it literally highlights the actual need of avoiding naming settlers as trustees or protectors, and that's to retain the proper independence on the trustee side, to take it away, and that's how it's so protected. That's why, they're kind of used, but they're very ancient mechanisms of modern finance that essentially are still used today, right? And it's always been the same. It was always for protecting trade rights back in the day, when you'd be off on your ship, you'd be kind of leaving some welfare. There would be a trustee who would then manage that wealth in the meantime while you're out there trading around the world. So, we should really make a video on the actual history of offshore trusts. It's truly fascinating when you do go into it. But other than that, guys, I'll leave you to it. Leave you to your nice sunny afternoon, hopefully, or your cold afternoon, depending where you are in the world. But hopefully I see you again soon. If you haven't met me before, I'm Will, and nice to meet you. And I look forward to speaking with you very soon. Ciao, ciao. Bye-bye.